Okay, so we have spent the last few modules kind of laying the groundwork, understanding the federal system, the separation of powers among the branches, and the foundational principles of federalism. And today, we're going to pivot, and I mean significantly pivot. We're going to move from the structure of the government to like the heart of individual liberties and equality in American constitutional law. And I believe that that begins with the 14th Amendment. And I know you might be expecting us to jump straight to the specifics of like the Bill of Rights, like the freedom of speech or the protections against the unreasonable searches and seizures. But we're going to start with a deep dive into the 14th Amendment. And there's a very important reason for this strategic choice. And that is to fully understand how most of the fundamental rights that we cherish apply to us in our daily lives, particularly in our interactions with state and local governments. We have to first understand that 14th Amendment. Okay. And it serves as like the constitutional bridge that extends all of these vital protections and its history. Also kind of introduces us to foundational concepts like the state action doctrine, which determines when the Constitution applies to behavior at all. Okay. So this amendment was part of the Reconstruction Amendments, and it represents a profound transformation in our constitutional landscape. So before its ratification, most of the rights that we associate with the Bill of Rights only applied to the federal government. And the 14th Amendment changed that equation fundamentally. And its understanding its origins and its early interpretations, I think is crucial for everything else that we're going to discuss for the rest of this semester. So let's set the historical stage, because the 14th Amendment didn't just appear out of nowhere. It emerged directly from the crucible of the American Civil War. And that was a devastating conflict that was fought primarily over the issues of slavery and states' rights. And the Union's victory brought about the end of slavery, which is where we get the 13th Amendment. That amendment proclaimed that neither slavery nor involuntary servitude shall exist within the United States. Now, we can also add that it does not say anything about those who are imprisoned, and that's a whole other debate, which I'll be happy to have with somebody one day. But it was a monumental achievement, okay, because it did end a cruel institution that had plagued the nation for centuries. And simply ending slavery, though, it wasn't enough, okay? You had millions of newly freed individuals, primarily in the former, Confederate states, who faced immense challenges. And despite being technically free, they were still largely without real rights or protections against the very state governments that had enslaved them. So you have many white Southerners at this time who were deeply resistant to the social and political changes that were ushered in by the war. And they quickly enacted what became known as the Black Codes. And these were highly restrictive state laws that were designed to control the labor and the behavior of the newly emancipated African Americans, effectively attempting to reestablish a system of racial control and oppression that was barely distinguishable from slavery. These codes, they denied them basic liberties, for instance, restricting where Black individuals could live. What occupations could they have? How could they contract? And even denying them the right to carry arms or to testify in court against white people. So in response to this injustice and this failure of individual states to protect basic civil rights, Congress passed the 14th Amendment. And they followed it 2 years later by the 15th Amendment, which granted voting rights to African American men. Remember, we women, we still didn't have a voice at this point. But together, these three are known as the Reconstruction Amendments. And while all three are vital, the 14th Amendment is arguably the most impactful in shaping individual rights jurisprudence, even to this day. And its opening words in Section 1 says, "No state shall." And it was absolutely revolutionary, okay? This was a direct and forceful restraint on state power, which was a stark contrast to the original Bill of Rights, which, as we noted, was seen only limiting the federal government, okay? So the ambition of the 14th Amendment was nothing less than a constitutional revolution. Okay. It was aiming to secure fundamental rights and equality for all citizens against infringement by state governments. But as we'll see, the Supreme Court's initial interpretation of this revolutionary text was, to put it mildly, quite conservative and largely frustrating this kind of radical promise of Reconstruction. So let's first dissect the 14th Amendment itself because it contains several crucial clauses, and we're going to focus on 3 today. We're going to look at the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause, okay? Now, we're going to begin with one that arguably held the most promise but was quickly kind of stifled, and that was the Privileges or Immunities Clause. So look closely at the text. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So on its face, this sounds incredibly powerful, or at least I think it does. But it suggests a broad federal protection for fundamental rights against state intrusion, okay? And many scholars and framers of the amendment, including key figures like Representative John Bingham, believed that this clause was designed to be the primary vehicle for protecting a wide range of fundamental civil rights from state interference. And this included things like the right to contract, the right to own property, the right to pursue an occupation, and other basic liberties often violated by the Black codes and other discriminatory state laws. And so the idea was to give these fundamental rights a federal constitutional anchor that was enforceable against the states. So this clause was almost immediately eviscerated by the Supreme Court in the 1873 case of the Slaughterhouse Cases. Okay, so this is a foundational case for understanding why our rights jurisprudence developed as it did. And many constitutional scholars view it as one of the most consequential and arguably wrongly decided cases in Supreme Court history. Okay, now in this case, it arose from a Louisiana state law that was passed, I think, in 1869. And Louisiana had granted a state chartered corporation, the Crescent City Livestock Landing and Slaughterhouse Company, a 25-year monopoly on the butchering business in New Orleans. And that meant that all other independent butchers in the city were effectively forced to use the monopolistic company's facilities and services for a fee. And they were prohibited from opening their own slaughterhouses within the city limits. This deeply impacted their ability to earn a living, okay, and to practice their trade freely. So you have a group of independent butchers that challenged this state-created monopoly, arguing that it violated their privileges or immunities as citizens of the United States, specifically their right to pursue their chosen trade and earn a living without such an arbitrary state restriction. And they essentially claimed that the state had unjustly interfered with the fundamental right to labor, arguing it was a privilege of the U.S. citizenship. Okay, so the question before the court was whether the Louisiana state law, again, which created this monopoly on butchering businesses, violated the Privileges and Immunities Clause of the newly ratified 14th Amendment by infringing upon the butcher's right to pursue their lawful occupation. And the Supreme Court, in a narrow 5-4 decision, ruled against the independent butchers. The majority concluded that Louisiana law did not violate the Privileges and Immunities Clause. So Justice Samuel Miller wrote the majority opinion, and he drew this controversial distinction between citizenship of the United States and citizenship of a state. And he argued that the 14th Amendment primarily protected only a very, very narrow set of rights that were flowing from federal citizenship, such as the right to travel to the seat of a government, to use navigable waters, or to protections on the high seas, right? Rights like pursuing an occupation, the court said, were privileges of state citizenship and thus remained subject to state control. And Justice Miller expressed deep concern for that a broader interpretation of the Privileges and Immunities Clause would fundamentally alter the balance of federalism, and that it would lead to a massive expansion of federal power over the states. And he feared that it would make the Supreme Court a perpetual censor upon all legislation of the states, thus undermining state sovereignty and turning the court into a national legislature. And he believed that the clause was intended to secure a very few express limitations on the power of the states, not to nationalize like the vast array of rights of state citizenship. And this narrow reading was a conscious effort to prevent the 14th Amendment from becoming a tool for broad federal intervention in state affairs. And that meant even if it meant limiting the protections that it offered to the newly freed slaves. Now, you had some dissenting, voices here, and the dissents in the slaughterhouse were passionate and correctly anticipating the future impact of the majority's constricted interpretation. Justice Field argued that the majority's interpretation rendered the clause a vain and idle enactment, essentially stripping it of any meaningful force. All right. Justice Bradley, in his dissent, stated that the clause was intended to secure all civil rights and all fundamental rights, privileges, and immunities, which appertain to the citizens of every free government, and that the majority had fundamentally misread the intent and the scope of the 14th Amendment. And these dissenting justices believed that the majority had undermined the very purpose of the Reconstruction Amendments, okay? So these slaughterhouse cases, they had a devastating and immediate impact. I mean, it effectively neutered the Privileges and Immunities Clause, like rendering it almost meaningless for over a century, okay? And this forced proponents of individual rights, particularly those seeking to protect the newly freed slaves who were facing very severe state-sanctioned discrimination, to find other avenues within the 14th Amendment to achieve their goals. And it was a massive missed opportunity for really some robust federal protection of fundamental rights in the immediate aftermath of the Civil War. And its shadow looms large over the history of civil rights in America. And modern scholars, including some of the Supreme Court justices, have since advocated for revisiting and revitalizing the Privileges or Immunities Clause, arguing that it was the clause originally intended to protect fundamental rights. So with the Privileges or Immunities Clause largely off the table due to the slaughterhouse cases, lawyers and advocates quickly turned their attention to the Due Process Clause of the 14th Amendment. And the text states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Okay? So this clause, as you can see, is quite broad, and it uses terms like liberty and property that are not precisely defined. And historically, due process primarily meant procedural due process, which was ensuring fair procedures before the government takes away a person's life, liberty, or property. So think about it like this. If the state wanted to take your land, it has to give you notice, a hearing, and pay you just compensation. This is about the how of government action, right? And we'll get much deeper into that, into procedural due process later. And we'll be focusing on what constitutes fair notice and a fair hearing. But in the late 19th and early 20th centuries, the Supreme Court began to interpret due process to also contain a substantive component, okay? And this concept, which is known as substantive due process, meant that the government must have a sufficient justification for infringing on fundamental rights, regardless of whether the procedures were fair. It's about the what of the law, not just the how or the procedure. It asks, is the state's reason for the deprivation substantively legitimate, or is it an arbitrary or illegitimate exercise of state power? And this was a significant and controversial expansion of judicial power. All right, so remember that we talked about Lochner already. And just to recap, this is where you had a New York law that had passed. It was called the Bake Shop Act, which limited the working hours for bakers to no more than 10 hours a day or 60 hours a week. And the state argued that this was a legitimate health measure because it was designed to protect the bakers from the dangers of working these long hours in these hot and dusty, poorly ventilated bakeries. Okay. And it was often done at night. So it could potentially lead to respiratory illnesses like tuberculosis. Okay. So the state was exercising its police power to regulate the public health and safety. So again, the question was whether the New York state law, which was regulating work hours, violated the due process clause of the 14th Amendment by infringing upon the fundamental liberty to contract between the employers and the employees. And the Supreme Court, again, a very narrow decision, it did strike it down, okay? And it found that it did violate the due process clause because it did interfere with the liberty to contract. And again, the court asserted that the right to make the contracts was a very implicit part of liberty that's protected by the due process clause. And they found that the New York law was not a legitimate exercise of the state's police powers, which its inherent powers were for regulating public health, safety, and morals, right? But rather, it was an unreasonable, unnecessary and an arbitrary interference with that ability to contract freely. And so the court was highly skeptical of the state's stated health justification, basically just saying that this is merely a pretext for labor regulation. And this is an attempt to equalize bargaining power between, employers and employees. And Justice Peckham, who wrote for the majority, he said that the general right to make a contract in relation to his business is part of the liberty of the individual protected by the 14th Amendment. And the court essentially imposed its own kind of economic philosophy of laissez-faire, okay? It was a belief in a minimal government interference in the economy onto the states, concluding that the states had overstepped its bounds and that the law was not truly a health measure, okay? So you have dissents that came in Lochner, and they were powerful, and they became highly influential in later constitutional thought. Justice Holmes, in his very famous dissent, argued that the Constitution is not intended to embody a particular economic theory, whether of paternalism or of laissez-faire. And he warned against judges substituting their own economic preferences for the judgment of democratically elected legislatures, urging judicial restraint. And Justice Harlan's dissent highlighted the legitimate health concerns for bakers and the deference owed to the state legislatures in making such policy judgments, essentially arguing that the majority had acted as a super legislature. So the impact of this Lochner era, as it became known, lasted for about 3 decades. And the court frequently was seen striking down, these various state and federal economic and social welfare regulations. You have the minimum wage laws, the child labor laws, and you have workplace safety standards. And they were based on this liberty of contract theory. And this approach was highly criticized for judicial activism, as the court was essentially, again, imposing its own economic and political views onto the country rather than simply interpreting the Constitution. And so the Lochner era finally ended in the late 1930s, largely, of course, due to the Great Depression and FDR's court packing threat, with the court retreating from actively reviewing economic legislation. So, but in the concept, the concept of substantive due process itself doesn't disappear. It actually reemerged as a powerful tool for protecting non-economic fundamental rights, such as the right to privacy, which we'll also get into in further weeks. But Lochner's specific holding, about the economic liberty is dead letter law, that you have this underlying idea of substantive due process that lives on, but it's in a different context, and it's focusing on fundamental personal liberties rather than economic ones. So finally, we come to the Equal Protection Clause of the 14th Amendment, which states that nor deny to any person within its jurisdiction the equal protection of the laws. And this clause, more directly than others, was clearly intended to dismantle the legal structures of racial discrimination that had developed after the Civil War. and ensuring that these former slaves received equal treatment under the law. It was not meant to ensure that the government could not make, arbitrary or discriminatory distinctions among people, particularly based on race. Okay. So, however, much like the Privileges and Immunities Clause, the Equal Protection Clause was severely it was handicapped by the Supreme Court's early interpretations. You have the famous example of one that would cast a long, dark shadow over American history for more than half a century, and that was Plessy versus Ferguson. And that was a case that cemented the legality of state-mandated segregation, and it validated the Jim Crow laws. So let's look at Plessy. So this case originated in Louisiana, and they had passed a separate car act. And that was a state law that was requiring railway companies to provide equal but separate accommodations for white and black passengers. And it penalized anyone who insisted on occupying a car not assigned to their race. So Homer Plessy was a man who was described as 7/8 white and 1/8 black, and thus he was considered black under Louisiana law. And he intentionally violated the act as part of an organized challenge. And he purchased a first-class ticket and sat in a whites-only rail car. When he identified himself as black and refused to move to a colored car, he was arrested and charged. So Plessy's lawyers argued that the law violated the 13th Amendment's abolition of slavery and the 14th Amendment's Equal Protection Clause, claiming that it imposed a badge of inferiority and it denied equal protection. So the issue before the court was whether a state law that was mandating the racial segregation on railway cars violated the Equal Protection Clause of the 14th Amendment, given that separate facilities for different races were purportedly provided as equal themselves. Okay. And the Supreme Court, in an 8-1 decision, upheld the Louisiana law, and they established the infamous separate but equal doctrine. Okay. So you have Justice Henry Billings Brown, who wrote for the majority, and he said that separate facilities did not necessarily imply inferiority or a badge of inferiority. If basically if the facilities provided for both races were equal quality. Okay. And Justice Brown wrote that the object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law. Okay. But in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality. Okay. So the majority believed that if the law was reasonable and for the public good, which they interpreted as maintaining public peace, maintaining order, racial harmony based on, prevailing social norms, and if the facilities were notionally equal, then it did not violate the Equal Protection Clause. Okay. And they argued that racial prejudice could not be overcome by legislation, and that legislation is powerless to eradicate these racial instincts, suggesting that segregation was merely a reflection of social custom and not a legal wrong. Okay. Now, remember, we had an 8-1 decision. So the dissent came from Justice John Marshall Harlan. Okay. The lone dissenter. And he delivered one of the most powerful and prophetic dissents in Supreme Court history. And he famously declared, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law." And he correctly predicted that the separate but equal doctrine would be used to justify these cunningly devised schemes to oppress African Americans, which would lead to a permanent system of segregation and racial hierarchy. And he understood that segregation, by its very nature, it stamped the colored race with a badge of inferiority, and that it was a clear violation of the 14th Amendment spirit and letter. And he warned that the decision would stimulate aggressions, more or less brutal and irritating, upon the admitted rights of the colored citizens. Okay? And so the impact here is huge because the Plessy decision provided the constitutional veneer for racial segregation, essentially the system of Jim Crow laws. And it was across the American South and beyond for the next 60 years. And it allowed states to maintain legally enforced segregation in virtually all aspects of public life, from schools and transportation to restrooms, water fountains, hospitals, so long as the facilities were deemed separate but equal, a standard that was truly almost never met in actual practice. And as Harlan predicted, the facilities were almost invariably inferior for Black citizens. And it would take until 1954, which was nearly 60 years later, for the Supreme Court to finally reverse this very devastating precedent. And that came in Brown versus Board of Education, which we will study in depth later on. But because we got to dive into the complexities of equal protection. But Plessy does remain a powerful reminder of how judicial interpretation can profoundly shape the social and political landscape of a nation, and sometimes for the worse. Now, to summarize our kind of early look at the 14th Amendment, which I still say was a revolutionary text, and it had transformative potential, but it was one that was, curtailed by the initial Supreme Court interpretations in the late 19th and early 20th centuries. But it leads us to our next kind of crucial concept, and that was how the rights contained in the Bill of Rights came to apply to the states at all. Given that these earlier rulings limited the 14th Amendment's direct reach. So before the 14th Amendment, the situation was absolutely clear. The Bill of Rights, which is those first 10 amendments that were guaranteeing the individual liberties like the freedom of speech, assembly, protection against unreasonable searches and seizures, those only applied to the federal government. And this was firmly established in the case of Barron v. Baltimore, which was a landmark decision that defined the scope of federal powers in relation to the state for decades. So let's look at Barron. So John Barron was the owner of a very profitable wharf in Baltimore, Maryland. And the city, in the course of making improvements to its streets and developing other parts of the city, diverted the flow of several streams. And this diversion caused large quantities of sand and silt to be deposited into the harbor, which drastically decreased the depth of the water around Barron's wharf. And that made it so that his wharf was unusable for most ships, and that effectively destroyed his business. So Barron sued the city of Baltimore, arguing that the city's actions had taken his private property for public use without providing him just compensation, in violation of the Fifth Amendment's taking clause. And he asked for monetary damages from the city, asserting that the Fifth Amendment should protect him from the state's actions. Okay. So the question before the Supreme Court was whether the Fifth Amendment's prohibition on taking private property for public use without just compensation applied to the state of Maryland and its subdivisions, specifically the city of Baltimore. Okay. And in more simple terms, did the Bill of Rights apply to state and local governments? And the Chief Justice John Marshall issued the unanimous decision against Barron. Okay. So Chief Justice Marshall firmly stated that the Bill of Rights was designed solely to limit the powers of the federal government and not the states. Therefore, the Fifth Amendment did not apply to Baltimore's actions. So Marshall's reasoning was rooted in the original intent and the structure of the Constitution. And he emphasized that the Constitution was established by the people of the United States as a government of enumerated powers operating on the states, and that the powers of the federal government itself were limited. Okay. And so he wrote that the amendments contain no expression indicating an intention to apply them to the state governments. And he reasoned that if the framers had intended to restrict state power with the Bill of Rights, they would have explicitly done so, just as they did in Article 1 of the original Constitution, which explicitly prohibits states from, for example, coining money or impairing the obligations of contracts. So, in his view, the absence of similar explicit language regarding the Bill of Rights meant that it did not apply to the states and that its protections were exclusively for the federal government. And he concluded that these amendments contain no expression indicating an intention to apply them to the state governments, and that because of that, this court also could not apply them. So, for the next 35 years or so, until the ratification of the 14th Amendment, the Barron versus Baltimore decision meant that the states were essentially largely free to infringe upon what we now consider basic rights without violating the U.S. Constitution. So if a state infringed on free speech or conducted an unreasonable search or denied a jury trial, there was no federal constitutional remedy. So individuals had to rely solely on their state constitutions or their state laws for protection. And that highlights the limited scope of the federal constitutional rights before the 14th Amendment and kind of underscores the radical shift that the amendment brought about. So let's talk about the transformative role here, because this situation dramatically changed with the ratification of the 14th Amendment, and specifically the Due Process Clause, which said, "Nor shall any state deprive any person of life, liberty, or property without due process of law," became kind of the primary vehicle here. And the Supreme Court began to interpret liberty protected by the Due Process Clause to include the most of the fundamental rights that were enumerated in the Bill of Rights. And so the very nature of this clause, starting with "no state shall," was key, providing that the textual hook that was missing in the Barron case. So this process is known as incorporation, and it's the step-by-step mechanism by which the Supreme Court, over many decades, had made most of the Bill of Rights protections applicable to the states through the 14th Amendment's Due Process Clause. So think of the 14th Amendment as a constitutional wormhole that pulls the rights from the Bill of Rights and extends them to the states, kind of ensuring that there is a more uniform application of fundamental liberties across the nation, okay? And there was a significant debate among the justices, particularly in the mid-20th century, about how incorporation should happen. Should the entire Bill of Rights be totally incorporated at once against the states? So you have Justice Hugo Black, who was a strong proponent of this total incorporation view. And he argued that the 14th Amendment it was intended to apply to the Bill of Rights in its entirety to the states without basically this judicial cherry picking, okay? And he believed that this would lead to more certainty and less judicial discretion, okay? In the alternative, should the court engage in selective incorporation, which was incorporating rights one by one as they arose in specific cases? So if they were deemed fundamental to our scheme of ordered liberty or deeply rooted in the nation's history and tradition. And so this selective incorporation approach, which was championed by Justice Cardozo and later Justice, I think, Frankfurter, it is the one that the court ultimately adopted and continues to follow, okay? And under this approach, the court looks at each specific right, like freedom of speech, protection against unreasonable searches, things like that, and they decide whether or not it is so fundamental to a fair and just system that it should apply to the states through the 14th Amendment's Due Process Clause. Now, today, almost all of the Bill of Rights provisions have been incorporated against the states. For example, your First Amendment right to free speech, it applies to your state university because it's been incorporated through the 14th Amendment's Due Process Clause. Your Fourth Amendment right against, unreasonable searches and seizures, it applies to the state police because it's been incorporated. Your right to, your Sixth Amendment right to counsel, it applies to state criminal trials because it's been incorporated. And this is a foundational concept that you have to grasp because when we're talking about a Bill of Rights protection applying to a state action, it's almost always thanks to the 14th Amendment. And we're going to return to the specifics of which rights were incorporated in a little bit, but let's keep going. So now let's talk about another crucial concept that's directly tied to the 14th Amendment, and it's one that often causes confusion, and that is the state action doctrine. Okay. And this doctrine is a fundamental threshold issue in almost every single constitutional rights claim that is brought against a state or local government. So the core principle is simple, okay, but it is extremely important. It's the 14th Amendment, and by extension, the Bill of Rights protections that it incorporates generally apply only when there is governmental action and not when there is private conduct. Okay. The difference is the government is infringing upon your free speech. If you get put in Facebook jail, that is not infringing upon your free speech. So why even have this limitation? The rationale, again, is rooted in federalism and the desire to preserve this sphere of private autonomy, okay? So the Constitution was designed to limit government power, not to regulate every single interaction between private individuals or entities. So if the Constitution applied to every single private wrong, it would fundamentally alter the relationship between citizens and between individuals in the government, individuals and businesses. I mean, it would potentially federalize all private relationships and disputes. And the idea is that the Constitution is a charter of government powers and limitations and not some kind of comprehensive code to govern private conduct. So this doctrine was famously established in the civil rights cases of 1883. And this case, like Plessy, had a very profound and tragic impact on the civil rights in America for many, many decades. These cases involved a challenge to key sections of the Civil Rights Act of 1875, which was a federal statute that was passed by Congress under its enforcement powers of the 14th Amendment. And this act explicitly prohibited racial discrimination by private individuals and businesses in public accommodations, such as inns and public conveyances, which would be like your railroads, theaters, and other places of public amusement. And it was a bold attempt by the Reconstruction Congress to outlaw private discrimination and to ensure that there was equal treatment for African Americans in everyday life after the failure of state governments to do so. And so several cases were consolidated, and including instances where you have individuals who were denied accesses to hotels and theaters, and again, even railway cars based on race. So, for example, a Black woman, she was denied a seat in the ladies' car on the railway in Tennessee. And then you have a Black man who was denied a seat in a New York theater. And so the issue before the court was, could Congress, under its power to enforce the 14th Amendment, specifically Section 5, which states that Congress shall have the power to enforce by appropriate legislation the provisions of this article, could they prohibit purely private discrimination in public accommodations? And the Supreme Court, in an 8-1 decision, struck down the key parts of the Civil Rights Act of 1875, ruling that Congress could not prohibit purely private discrimination under the 14th Amendment. And the court found that the act was unconstitutional because it reached beyond state action. So Justice Joseph Bradley wrote for the majority and said that the court reasoned that the 14th Amendment, including the Equal Protection Clause, only prohibits state action that discriminates and not private action. And he very famously stated that the amendment does not invest Congress with power to legislate upon subjects which are within the domain of state legislation. And so he argued that the 14th Amendment was designed to counteract state laws and official state acts of discrimination, not to regulate the purely private conduct of individuals or private businesses. And he emphasized that this individual invasion of individual rights is not the subject matter of the amendment. Okay. So Congress's power under Section 5 was deemed remedial, meaning that it could only remedy state sponsored wrongs and state failures to protect rights, not create new federal rights against private actors or regulate purely private conduct. So the court suggested that if individuals were injured by private discrimination, they should seek remedies from state law, not federal constitutional law, essentially pushing the burden back on the state governments, which had already largely failed to protect those rights. Now, again, we have our lone dissenter, which is Justice John Marshall Harlan. And again, delivering a very powerful rebuke to the majority. And he argued that the 14th Amendment should be interpreted more broadly to give Congress the power to address a history of state-sanctioned oppression that resulted in racial subordination. And he saw the denial of equal access to public accommodations again as this badge of servitude that the 13th Amendment intended to eliminate, and that the 14th Amendment was meant to prevent states from allowing such discrimination to go on. And he pointed out that what the state may not do, Congress may forbid. And he recognized that private action, especially in places that were effectively public spaces, could inflict constitutional harms that the 14th Amendment was meant to address. And his dissent is often cited as a clear articulation of the intent behind the Reconstruction Amendments, arguing that the court's decision essentially rendered the 14th Amendment's protections useless in many practical aspects of daily life. And this decision was a catastrophic blow to the efforts to protect the civil rights in the post-Reconstruction era. Again, it left African Americans essentially vulnerable to this widespread private discrimination in housing and employment, public accommodations, and so much more, with no federal constitutional remedy. And it meant that until Congress passed new comprehensive civil rights legislation under its Commerce Clause power in the 1960s, which again was like nearly 80 years later at this point, a private hotel owner, a restaurant, a theater, they could all legally refuse service to someone based on race without violating the U.S. Constitution. Because again, their refusal was considered private action and not state action. And that decision, combined with Plessy, created the legal framework that allowed the Jim Crow segregation to flourish for decades. It's a stark reminder of the limits that the Supreme Court had placed on Congress's power to enforce the constitutional rights and of the enduring importance of state action doctrine in shaping the reach of federal protections. So while the state action doctrine generally limits the 14th Amendment to government conduct, there are narrow exceptions where private conduct can be deemed state action. And these exceptions are important because they recognize that sometimes the line between the public and the private can blur, and that the state can be so involved in private action that it effectively becomes a state actor for constitutional purposes. Now, these aren't easy cases for the court to decide, and the court has generally taken a cautious approach to expanding these exceptions, basically wanting to preserve a realm of private autonomy. And the first exception is the public function exception. This is going to apply when a private entity performs functions that are traditionally and exclusively governmental. And the key word here is exclusively. So it's a very high bar, meaning that the function must somehow be something that only the government has historically provided, and which the private entity is now performing in place of the government. So let's talk about Marsh v. Alabama, because this case illustrates a very particular and somewhat unique factual scenario where a private entity takes on all of the characteristics of the government, making the actions subject to constitutional scrutiny. So this case involved a Jehovah's Witness named Grace Marsh, who was attempting to distribute religious literature on a sidewalk of a privately owned company town called Chickasaw, Alabama. Now, this town was entirely owned by a private corporation, which was the Gulf Shipbuilding Corporation. Now, Chickasaw functioned in every practical sense like a regular municipality. It had residential areas, commercial blocks, streets, stores, post office, public services, even had its own police force, and it was open to the general public, including through public roadways. And Marsh was told by the company that she could not distribute her literature without a permit, which she was denied because she didn't have a permit from the company. She persisted on and was subsequently arrested and convicted under an Alabama statute for trespassing on private property, which typically would be a matter of private property rights. So the issue was, could the private corporation's actions, despite its private ownership of the town, be considered state action for the purposes of the 14th Amendment, thereby applying the First Amendment right to free speech, because the company town was performing a public function that was traditionally reserved for the government. And the Supreme Court held that despite being privately owned, the actions of the company town in restricting speech constituted state action, because the town performed a public function that was normally associated with the government. So therefore, the First Amendment applied, and the company's ban on distributing literature was unconstitutional. So Justice Hugo Black wrote for the majority and said that the court recognized the unique nature of the company town, which had all the outward appearances and functional characteristics of a traditional municipality. And Justice Black wrote that the more an owner for his advantage opens up his property for use by the public in general, the more do his rights become circumscribed by the statutory and constitutional rights for those who use it. And the court balanced the company's property rights against the citizens' First Amendment rights and concluded that the people who lived in this company-owned towns were free citizens of the state and nation, and they're entitled to all the liberties that are guaranteed by the 14th Amendment. And this was because the corporation had effectively taken on this full range of municipal functions, creating this public forum on private land that was indistinguishable in its practical operation from a normal town. So to allow the corporation to restrict speech in such a setting would allow it to effectively circumvent the constitutional limitations on the government. So Marsh v. Alabama established the public function exception, but it is a very narrow one. It does not mean that every public-facing private entity, like a large, shopping mall, automatically becomes a state actor because it serves a public purpose or provides, public space for public gatherings. And subsequent cases have largely limited the public function exception to situations where a private entity performs functions that are exclusively and traditionally reserved to the state, such as like running elections or operating an entire town. So, for instance, the court has consistently said that private shopping malls, even if they are popular gathering places, they aren't the same as a company town exercising all municipal powers, and thus they do not have to allow free speech within their premises under the 14th Amendment. The First Amendment alone. I'm sorry. State constitutions sometimes offer, more broad protections. Now, the second, often more complex exception is the significant state involvement or the entanglement exception. And this arises when the state's actions are so intertwined with or they significantly encourage or even facilitate private discriminatory conduct that the private action becomes attributable to the state. And it's not just about the state regulating a private activity. It's about the state being so responsible for or approving of the specific private action that it effectively becomes a state actor itself. That brings us to the landmark case of Shelley v. Kramer. And this was a pivotal civil rights decision that came long before Brown versus Board of Education. But it was instrumental at chipping away at the legal foundation of segregation, especially when it came to housing. So this case involved racially restrictive covenants, and these were private agreements between the property owners in certain neighborhoods that prohibited the sale or transfer of properties to African Americans or other minority groups. For example, a deed might contain a clause saying, "This property shall never be owned or occupied by any person not of the Caucasian race." And those covenants were so common, particularly in the early to like mid 20th century. And they were used to maintain segregated neighborhoods. So in this specific case, a black family, which is the Shelleys, they had purchased a home and apparently without the knowledge of such a restrictive covenant. So other white homeowners in the neighborhoods, including the Kramers, then sued the Shelleys in state court to enforce the covenant and block the Shelleys from being able to take possession of their home. So they sought a judicial injunction to prevent the sale, effectively asking the state's judicial power to enforce a discriminatory private agreement, which was valid under the Missouri state law at the time. So the issue before the court was, could a state's court, enforcement of a privately agreed upon racially restrictive covenant be considered state action for the purposes of the 14th Amendment's Equal Protection Clause? And the Supreme Court held that while the private racially restricted covenants themselves were not state action, the state court's judicial enforcement of those covenants did constitute state action, and that such an enforcement was a violation of the Equal Protection Clause of the 14th Amendment. So you have Chief Justice Fred Vinson, who wrote for the majority, and he said that the court explicitly stated that the 14th Amendment does not address purely private conduct. However, it reasoned that when state courts lend their power and their authority to enforce private agreements that, if enacted as state laws, would violate the Equal Protection Clause, then that judicial enforcement itself becomes the state action. And the court explained the short of the matter is that the action of the state courts in enforcing the covenant in these cases is state action within the meaning of the 14th Amendment. We have no doubt that there has been discrimination by the states in these cases. So the state, through its judicial branch, was essentially using its coercive power to deny individuals the equal protection of the laws based on race, which was prohibited by the 14th Amendment. So the court made clear that discriminatory state action is forbidden, whether it takes the form of legislation, executive action, or judicial action. So allowing the courts to enforce these types of covenants would be no different than a state legislature passing a law requiring racial segregation. So Shelley versus Kramer was a huge victory for civil rights because it prohibited the state courts from enforcing these racially restrictive covenants. And it was a creative and impactful use of the state action doctrine to strike down a widespread mechanism of housing discrimination. However, it didn't actually ban the covenants themselves or even purely private discrimination. It only prohibited state enforcement. So people could still voluntarily agree to such covenants, and private actors could still discriminate in real estate transactions, but they couldn't go to court to force somebody to abide by a discriminatory covenant. And that means that a private discrimination in housing continued in many forms until Congress later passed the Fair Housing Act in 1968. And this directly prohibited such discriminatory practices in housing. Now, let's look at one more case. I think it's one more case. It might be two, but let's look at the case that defines the limits of the state involvement exception, which is the Jackson versus the Metropolitan Edison Company. And this case clarifies that not all state involvement or regulation of a private entity makes that private entity a state actor. So this case involved a private utility company, which was Metropolitan Edison, which was a heavily regulated by the state of Pennsylvania's Public Utility Commission. And it held a certificate of public convenience from the state to provide electrical service, essentially giving it a partial monopoly on its service area. So the company terminated a customer's electrical service, and that was Jackson, without any kind of notice or hearing, alleging non-payment. And Jackson sued, arguing that the termination without a hearing violated her due process rights under the 14th Amendment. And she contended that because the utility was extensively regulated, had a monopoly, and provided an essential public service, its actions should be considered state action subject to constitutional constraints. So the issue before the court was, did the private utility company's termination of electrical service, given its extensive state regulation and the monopoly status, Did it constitute state action for the purposes of the 14th Amendment's Due Process Clause, thereby requiring it to provide notice and a hearing? And the Supreme Court held the private utility company's action did not constitute state action. Therefore, the 14th Amendment's Due Process Clause did not apply, and Jackson's constitutional claim failed against the utility company. So, Justice William Rehnquist, he wrote for the majority, and he stated explicitly the court rejected the argument that extensive state regulation of a private business automatically transforms the private business actions into state action. And the court explained that merely being regulated or receiving a state-granted monopoly was not enough to create state action unless the state was responsible for the specific challenged conduct, okay? So there needed to be a sufficiently close nexus between the state and the private entity, so much so that the state could be said to be responsible for the specific private conduct. Now, in this case, the state had merely approved the company's, general tariff procedures, which included the right to terminate service, but it had not compelled or significantly encouraged the specific termination of service without a hearing. So the court found that there was no symbiotic relationship where the state and the private entity were effectively joint participants in a common enterprise. Now, that was distinguishing from an earlier case, which was Burton v. Wilmington Parking Authority, where there was a state-run parking facility that leased a space to a discriminatory restaurant. But in this case, the state's pervasive regulation was found to be insufficient to make the company's specific decision to terminate that service an act of the state. And the fact that an entity provides an essential service does not in itself make it a state actor. So Jackson versus Metropolitan Edison Company helped to solidify the principle that pervasive state action or even a state-granted monopoly by itself is usually insufficient to establish state action. The court requires a more direct connection, or an entanglement, if you will, between the state and the particular challenge conduct. And that reinforces the general principle that the Constitution is primarily a restraint on government, not private actors. So it means that most of these private entities, even large and powerful ones that are providing these essential services, are generally not subject to the direct constraints of the 14th Amendment unless they fall into one of the narrow exceptions, like the public function test or a very specific entanglement that directly compels the unconstitutional action. So it places a high bar for finding state action in private entities, making it more difficult to bring constitutional claims against them, okay? So, just to summarize, state action, that's a critical gatekeeper. If there's no state action, then typically there is no constitutional claim under the 14th Amendment and the Bill of Rights. Now, however, Marsh and Shelley both show that the line between the private and state action can be blurry, and the court has crafted narrow exceptions to address situations where private entities effectively assume governmental roles and where the state significantly enables or enforces private discrimination. But Jackson reminds us that these exceptions are not easily met, setting a high bar for finding state action in those private entities. So we've laid out the foundational concepts, and understanding these, like the 14th Amendment structure, the history of its interpretation, the incorporation doctrine, and the state action requirement with its narrow exceptions, is absolutely essential. They are the lens through which we will examine virtually every individual right and liberty as we continue to discuss the Constitution. And when you analyze a constitutional problem that involves a state action, your mind should immediately jump to the 14th Amendment and state action doctrine before you even begin to consider the specific right at issue. Next, we're going to start digging in and looking at the First Amendment and understanding how its protections extend to state actors and where the limits of those protections lie. Let me know if you need anything. Bye.